Hello and welcome back. I'm attorney Jason Rice, attorney and founder of DiRogo Divorce, a full-service family law firm located in southern Maine. And I wanted to talk about a question that I get often regarding family law cases, which is what is mediation? If your case involves children, especially, whether it does involve children or not, almost certainly the court's going to order that the parties attend mediation. And mediation is an opportunity for the parties to kind of get together and informally try to resolve all of the issues or some of the issues that take place in that case. So, for example, if it's a divorce and there's children involved, the issues that the court would ultimately need to address would be how to divide up marital property, whether or not to award spousal support. And then if there's children involved, parental rights, responsibilities, where's the children going to live most of the time? That's primary residency, what the child support amount is going to be, and a contact schedule. So at mediation, those are all examples of things that the mediator could address. So the court would order the parties to attend mediation. Oftentimes it's taking place by Zoom. Other times it's in person. Either way, whether it's in person or by Zoom, the mediation is going to look the same. One party is going to be in one room, the other party is in the other room, and the mediator will go back and forth trying to resolve the issues that might be in the case. One room might propose something, they take it to the other party, they talk about it, either they agree or don't, maybe they have a counter proposal and they go back. It's not an adversarial process, the mediation. There's no presenting of evidence. It's literally the parties sitting down, separately with the mediator trying to resolve some of all of those issues. Whatever does get resolved, if they reach an agreement on how property is going to be distributed or on some of the child issues or all of them, the mediator will type up a points of agreement form and kind of memorialize what the parties have agreed to. And that will get sent to the court, and then the court can enter that as a judgment. The parties at a mediation could agree that what they've resolved is on an interim basis or on a full-time basis or on a final basis. Either way, if it's final basis and they've reached an agreement on all issues, typically at the next court event, the court will try to put the agreement on the record. And that could be it. The court could finalize the divorce if it was a divorce case. If it's a parental rights or responsibilities case, then the court could finalize it then. But mediation is a great way to resolve these issues. Oftentimes, the courts will have the parties mediate at least twice. If they think it's helpful, they'll request maybe a third or so mediation. And that way they're kind of staying out of that adversarial nature of a final hearing, but working together as best they can to reach a resolution on the issues that they have power and a say in. And that is ultimately the best benefit of mediation, is that if the parties can work together for that limited period of time to reach a resolution, they've actually crafted it and came to the terms themselves versus letting a judge make that determination. Because at the end of the day, the judge doesn't know either party, doesn't know the children, doesn't know the property that's involved, etc. So it's always best if the parties can do that themselves and reach an agreement, because they would have a more meaningful impact as to what the outcome of the case is. If you have any questions regarding mediation, feel free to reach out to DiRogo Divorce, www.dirigo-divorce.com, or to call 207-200-3231. We'd be happy to set up a consultation to discuss what your family law case looks like and what some of those options might be.